Ladies and gentlemen, welcome to the National Constitution Center on the road. I'm Jeff Rosen, the president of the National Constitution Center in Philadelphia, which is a very important and special American institution. It's the only institution in America that was created by the US Congress to disseminate information about the US Constitution on a nonpartisan basis in order to increase awareness and understanding of the Constitution among the American people. And the cornerstone of our efforts in this inspiring educational mission is a wonderful partnership between the Federalist Society and the American Constitution Society, these two great lawyers' organizations that have joined together to educate the public about the constitutional issues at the center of American life. We are doing this on a host of media platforms. The centerpiece of our online efforts is the Interactive Constitution, co-sponsored by FedSoc and ACS, which has nominated the top liberal and conservative scholars in the country to write about every clause of the Constitution, describing what they agree about and what they disagree about. So using this amazing and free online tool, which has gotten 12 million hits since it launched a year ago, you can click on the Fourth Amendment, which is the amendment we're going to be talking about today, and see two of America's leading Fourth Amendment scholars, Orin Kerr, who's sitting right next to me, and Barry Friedman of NYU, with 1,000 words about what they agree the Fourth Amendment means, and then separate statements about what they disagree about. As it turns out, one of the central things that Friedman and Kerr disagree about is the application of the Fourth Amendment to ubiquitous surveillance in public places. And that is the topic we're going to be talking about today. This is part of a series called America's Traveling Town Halls. We are traveling across the country, from Dallas to San Francisco to Chicago to Washington, D.C., to debate the constitutional issues of the news. This town hall is sponsored with the support of the Bernstein Family Foundation. And I'm so glad that Amy Bernstein and her family are here to support us and watch it today. And as it happens, ladies and gentlemen, this is, I think, the town hall I'm most excited about because I need to know the answer to this question just as you do. The Supreme Court on November 29th will hear a case called U.S. versus Carpenter that could be the most important case involving digital privacy of the 21st century, or it could be a modest case applying existing law in ways that won't fundamentally transform the law. And we have here two of America's leading experts to help us think through this crucial question. It's going to be a Charlie Rose-style conversation, but I'm going to ask you to vote before and after the debate, because that's what we do at the Constitution Center. And the winner of the debate is not the person who gets the most votes, but the person who changes the most minds. So approach this question with an open mind and separate your political from your constitutional views. That's the rule of all of our Constitution Center debates. In other words, you might think that tracking someone's movements for 127 days using their cell phone geolocational data is a great idea, but the Fourth Amendment forbids it. Or you might think it's a terrible idea, but the Fourth Amendment allows it. And by evaluating the arguments you're about to hear in constitutional terms, you will elevate yourselves about this central question involving privacy in America. All right, I am here as the moderator of this debate. I'm here in an entirely nonpartisan spirit. Some of you who have read some of my stuff may conclude that I have views on the question, but I have no views whatsoever. So I'm entirely neutral here, and I'm going to try as neutrally and quickly as possible to describe the facts of the case and a couple of the recent Supreme Court cases that the court will be applying, and then we're going to jump right into it. So this is a case called U.S. versus Carpenter, and it involves a guy whose movements were tracked in public for 127 days. The government did that by issuing a subpoena for the geolocational records from his cell phones that made it possible to see which cell phone towers he was near. And using this geolocational data, they were able to conclude that he had indeed committed a series of armed robberies, including armed robberies of stores that sold cell phones. And after concluding that he was a cell phone robber using his cell phone data, they indicted and convicted him. He objected that the search was invalid because the subpoena that was issued under a federal law called the Stored Communications Act to get this data wasn't issued according to the standards required by a valid judicial warrant. And as a result, Carpenter said that this search violated his rights under the Fourth Amendment to the Constitution, which protects the right of the people to be secure in our persons, houses, papers, and effects against unreasonable searches and seizures. So that's the text that we're going to be interpreting today. The Supreme Court has said a bunch of important things about the Fourth Amendment, but there are maybe 3 or so really leading cases that I just want to put on the table right now. In the 1970s, the court decided an important case called Smith versus Maryland. And that was a case where a guy made a series of phone calls, and using, if I've got it right, a pen register technology, the government was able to reconstruct the numbers that he dialed. And the court said that he had no expectation of privacy in those numbers because he'd voluntarily surrendered the numbers to a third party, namely the telephone company, and therefore the government could seize them without a warrant. And one big question in this case is whether that third party doctrine applies to a case where there's the collection of a whole lot of geolocational information that can reconstruct our movements in a really granular way. More recently, in a case called US versus Jones, the government tracked a suspect's movements using a global positioning system device. And they stuck it on the bottom of his car and tracked his movements in public for a month. That might sound a lot like this case, but there was an important difference. The police had to walk onto the guy's driveway and physically affix the device on the bottom of his car. And based on that, the court held, in an opinion by Justice Scalia, that any physical seizure with the intent of collecting information triggered the warrant requirement. That decision was unanimous, and there was a concurring opinion by Justice Samuel Alito, who said that physical trespass wasn't necessary, and any virtual search that could reveal a lot about our movements in public, including our intimate associations and our thoughts and our political views, might require a warrant. And then finally, there's a case called US versus Riley, where the police wanted to search a guy's cell phone after they arrested him. And the government said our cell phones are just like cigarette packets, which the government is allowed to open if someone is arrested because they might contain contraband. But the court unanimously rejected that argument. And in an opinion by Chief Justice John Roberts, the court said, our cell phones are nothing like cigarette packets. They can require our hopes, our dreams, our intimate associations. They can reveal so much about us that to search them without a warrant is like the general warrants that sparked the American Revolution. And Chief Justice Roberts quoted James Otis as saying at the moment that the British king issued a suspicionless warrant for information, at that moment the child revolution was born. Okay, so that's my totally nonpartisan summary, and I now want to take a straw poll about what you feel based on what you've heard so far about the case. Do you believe that reconstructing someone's movements in public for 127 days by subpoenaing the geolocational information from his cell phones violates the Fourth Amendment right against unreasonable searches or seizures of our persons, houses, papers, or effects? Who believes the Fourth Amendment is violated in this case? And who believes that it is not? Wonderful, that's a good mix of views. It's not quite 50-50. I saw a slight majority in favor of a violation, but there's clearly a division. And that's good because, as you're about to hear from our debaters who disagree strongly about this case, this is, as Orin called it, a hard case. Orin, you called it a hard case. You filed a brief in the case. Start by amplifying anything you would like to about my description of the facts, including telling our audience how granular is the geolocational information revealed by these cell phone pings, and why is it or is it not like a GPS device?
Great. Well, thank you, Jeff, for the invitation to be here, and to Alex for being here. I've been a fan of both of your work, and I'd never actually met Alex until today, so that was a nice thing to be able to do after interacting online for a long time. So let me first say that everyone agrees that there should be legal limits on government access to historical cell site records. There's a federal statute. It's not a subpoena standard. It's the Stored Communications Act has a specific and articulable fact standard that Congress enacted in 1994 that says if the government wants to get historical cell site records or any other stored non-content account records for internet accounts or telephone accounts, they have to go to a federal judge, they have to make the case based on specific and articulable facts that the evidence to be obtained is material to an ongoing investigation. And everybody agrees that there should be some limits, and the statute is there. Many states, I think 8 or 9 states at this point, have enacted a higher threshold, a warrant standard, as a matter of statutory law for their own law enforcement access. So everybody agrees that this isn't a debate about whether there should be any limits on government access to historical cell site records. This is a debate as to which institutions of government should be the ones that put those limits on government access. Should it be the legislature, which has traditionally asserted this role, or should it be the courts? So the idea is maybe we should have, I think, Jeff, you called it a revolution, or transforming the role of the Fourth Amendment. So the Fourth Amendment should now limit this thing which traditionally has been up to statutes. And I think the existing traditional approach of having this be a matter of statutory law, the limits be imposed by statute, at whatever standard, and we can talk about whether the standard as a matter of policy should be the current Stored Communications Act standard, or maybe the warrant approach that some have wanted and that the House Judiciary Committee has had, I think, 5 different hearings about over the last 10 or 15 years. But the real question is which institution of government is providing these limits? And in terms of the detail of these records, not very detailed. So let me also challenge some of the way you framed this. Following a person, their movements over 127 days, it sounds really, really invasive. Although the record in this case and other similar cases suggests that the information the government reveals is not nearly as invasive as that. So first, the government never proves a case based on historical cell site records. These are records that providers generate in the ordinary course of business. They use it to optimize their network. They create these records. These are the records of which cell towers were used to connect a call when the phones were on and communications were coming to and from the phone. The cell companies keep these records as to where the towers were. It helps them with their network. The record in Carpenter suggests, I think just a little bit of testimony suggesting it's within a mile or two, a mile and a half or two. So it's basically maybe the neighborhood that somebody was in or the part of town that somebody was in. The records don't show what block they were on. They don't show what house a person was inside. They don't show what room they were in. It's not GPS type records that are showing exactly where somebody is over time. Instead, it's when a communication comes in or out, a phone call comes in or out, or a text message comes in or out, we get a record as to the neighborhood, essentially, of where the cell tower was. We know where the tower is, and we assume that probably the person was with their phone, and the phone would have been somewhere in that neighborhood of a mile or two. So these are location records, yes, but there are a lot of records are location records in that sense. So if you think about it, credit card records, automatic license plate readers, bank records. A lot of times records can reveal where somebody is located. In fact, the traditional phone calls would reveal where someone's located exactly because you'd know where the phone was. These are records about what neighborhood a person is in. Traditionally, the Fourth Amendment rule would be you only get Fourth Amendment protection if you're in a place that is protected by a reasonable expectation of privacy and you've not revealed that information, exposed it to outsiders. The traditional rule, which got dubbed the third-party doctrine, which I think is really the exhibiting a subjective expectation of privacy test, is that when you reveal information to a third party, you give up your Fourth Amendment rights against that information. What this would mean in this context is when you hire a cell phone company to deliver your calls, so you don't have to go out into public and travel to communicate with somebody, you're essentially creating a third-party eyewitness who can testify to the government as to what information they have about how the call was delivered on a person's behalf. And that information will happen to reveal which cell tower was used, which gives a rough information about location. But that information about how the communication was delivered, the metadata, not the contents of the call, but the third-party business record is the business record of the company, and so I think should not be protected under the Fourth Amendment, as it never has been. This rule that metadata of communications is not protected really goes back to the first main big Fourth Amendment case, Ex parte Jackson, in the 19th century, dealing with the postal communications, was adopted again in Smith versus Maryland in 1979 for telephone calls. So this is the traditional Fourth Amendment rule. You can't disclose information to somebody and then expect the Fourth Amendment to act as kind of a non-disclosure rule, limiting when the government can get access to that information. The government can issue subpoenas saying, testify about what you know. They can do that to the phone company here under the Stored Communications Act, which requires this higher court order. And I think that statutory approach is the correct one and that regime should not be defeated under the Fourth Amendment.
Great. Thanks for setting us off so well. So Alex, Orin just made a bunch of important points. First, it sounds like you guys have a big disagreement about the facts. In your brief, you say it's not just that you can see what neighborhood someone was in, but this technology is evolving in a way that cell phone pinging will reveal not only within 50 meters, but soon underground in the New York subways and the time that you're attending a particular political rally. So you say in your brief that it really is more like a GPS device than a telephone. And then you say that this whole application of the third-party doctrine to a world where you can reconstruct someone's movements so granularly should be reconsidered, as Justice Sonia Sotomayor said in her concurring opinion in the Jones case. So tell us about both of those points.
Yeah, absolutely. And let me start, too, the same way Orin did, by just thanking you, Jeff, and thanking Orin. It's a pleasure to be here. I'm looking forward to the conversation. So let me start with the facts and then get into, there's a lot to respond to what Orin said. So yes, that's right. This technology is evolving in such a way that the facts of Carpenter itself are somewhat irrelevant to the broader debate, because the cell site location information, which is what is at issue in Carpenter, already today is significantly more granular in detail in most major metropolitan areas than the information that was available to the state in Carpenter. But even with respect to Carpenter, Orin, it is true that individual pixels of cell site location information do not individually reveal as granular information as the Carpenter brief suggests, the brief on behalf of Carpenter. But when you set those pixels next to each other, as our brief explains, which is on behalf of technical experts, the ambiguity, the resolution gets higher and the ambiguity gets lower, because you learn more by placing them next to each other. But in some ways, that's, I think, irrelevant to the broader debate, because this case isn't really about whether less granular information or more granular information is protected by the Fourth Amendment. It is really whether the Fourth Amendment has anything at all to say about the collection of information that is stored on the parties, the servers of third parties. Really, whether the Fourth Amendment has anything to say about modern surveillance, digital surveillance that relies by and large on information stored in the possession of third parties. And so it's a bit of a red herring to say, to fight about the granularity of the information in Carpenter, because if the theory that the government is advancing in that case, or Orin's theory, were accepted by a court, then all of those considerations would be irrelevant. It wouldn't matter if the information were extremely granular, if it revealed exactly where you were every second of every day of every week in the year. It wouldn't matter if the government knew every single person with whom you corresponded by the metadata in your email. It wouldn't matter if they were able to connect that to every credit card transaction you ever made going back in perpetuity. It wouldn't matter if they also had the same records of every one of your associates, and so could build a social map of your world and understand exactly the way you're communicating. None of that would matter under the third-party doctrine theory, because that theory holds that by the simple fact of providing that information to the social media companies, to our email providers, to our telephone companies, to our credit card companies, all of a sudden becomes unprotected by the Fourth Amendment. And that doctrine did, for some time, provide, I think, a useful approximation of privacy in the analog world. It I think, was, by and large, an accurate approximation of what people expected and what was reasonable for people to expect in terms of their privacy in the analog world. But I think that there are two problems with that. First is that the doctrine came with a shelf life. The Supreme Court was never fully committed to the logical extremes of the third-party doctrine. And we know this because in 1983, in one of the important cases relevant to this, in a case called Knott's, the Supreme Court said people don't have an expectation of privacy in their movements in public, and so the government can monitor somebody's movements in public. And the Supreme Court said the petitioner in this case doesn't actually quibble with that premise. What the petitioner is worried about is that if we approve that rule, the government will start to engage in 24-hour-a-day, 7-day-a-week surveillance of US citizens. And the court carved off that question. It said when the government starts doing that, and it called it, I think, dragnet-type surveillance, then there will be time enough to re-examine the constitutional principles that apply. And that time is now. Because to extend the third-party doctrine to the digital world would be to render the Fourth Amendment a dead letter for most of the surveillance that matters today. The world that is not connected to the internet is shrinking. And that is the world in which the third-party doctrine would confine the Fourth Amendment, to this increasingly shrinking world of physical surveillance and then some amorphous category of content surveillance online. And I don't think that's the role that the Fourth Amendment was meant to play. I think it had higher reaches than that, and I think it has always been meant to be responsive. And one example of that is the Supreme Court's decision in Riley, the one that you mentioned, Jeff. That case, like this one, involved an argument being made, and I actually don't know, Orin, if you submitted a brief in that case. But the government, that case involved a search incident to arrest. And there's long been an exception to the warrant requirement for searches incident to arrest. If the government arrests you, it can search what's on you physically. And in that case, what was on Riley physically was a cell phone, a smartphone that had a lot of information on it. And the government argued that's no different. The search incident to arrest doctrine says we can search that cell phone because it is physically on his person. And as Jeff said, a unanimous Supreme Court rejected that. Not because the logic of that doctrine didn't apply, but because applying it to the digital context was such a radically different factual foundation that you had to re-examine first principles. Chief Justice Roberts said that any extension of the doctrine, which was articulated in cases like Schimel and Robinson, had to rest on its own bottom. I think that was a phrase that he used. And I think the same is true today. I think it's not enough to say that the third-party doctrine exists. We should apply it to digital records. I think we have to understand the importance of the Fourth Amendment and see whether it is consistent with an application of that doctrine to digital records, and I don't think that it is.
Great. Well, we have a firm disagreement about whether or not to apply this third-party doctrine to a digital world or not. And before we talk about the alternatives, Orin, let's just talk about how this Supreme Court is likely to approach this case. In the Jones case, Justice Alito said that you don't need physical trespass to trigger the Fourth Amendment when you have an electronic search that reveals a lot about us over a long period of time. And he was joined apparently by, let's say, 5 justices, if you count Justice Sonia Sotomayor. Justice Scalia said you need physical trespass, and Alito said it doesn't make sense to focus on trespass because you could get the same amount of information from the guy's geolocational records. So just applying the Alito concurrence, which was based on the idea that by putting a lot of information together, you can reveal a lot about us. Would that not lead to, or would that or would it not lead to a victory for Carpenter, and how much does the granularity of the information affect your answer to that question?
Yeah, so I think it's really hard to predict what the Supreme Court's going to actually do in the Carpenter case. And the problem is all of the precedents that have come up before, and there's only a few, Jones and Riley are the recent cases, Quan, if you want to go back, although that didn't hold very much. There are lots of ways to distinguish those cases, and it's kind of unclear how the justices are going to react to efforts to draw those similarities. And the third-party doctrine and undercover cases on which the traditional doctrine is based all predate the arrival of the current set of justices. So none of them have ever ruled on a third-party doctrine case before, and it's just really hard to predict what they might do. In terms of the Jones concurring opinions, this is what Carpenter really rests his case on, the mosaic theory, the idea that short-term obtaining records is okay, short-term surveillance is okay, but at some unidentified point you get so much information that it sort of retroactively all becomes a search in the collective, which I think is a pretty novel and radical idea. The court has never adopted that view as a majority. Will it? I mean, it's certainly possible that this will happen. There are lots of major problems with actually trying to adopt that theory, like how long is long-term enough? How do you measure the aggregation? What techniques are aggregated? How do you do multiple techniques? What if it's multiple investigations? Any effort to try to implement this theory, I think, is ultimately doomed because there are so many questions that would come up. You'd need a full-time Supreme Court only answering how to implement the mosaic theory, which would essentially lead them to draft a statute regulating long-term surveillance, which is what Congress has already done. So I think this really is a classic, quintessentially legislative role of trying to draw these lines that Carpenter thinks the court should draw, although interestingly, Carpenter refuses to say what those lines should be. Carpenter just says, in future cases, there will be opportunities to draw the line. Sort of like, don't worry about how to implement this approach, punt that to some future case, give me a victory here and you all can figure out the headaches down the road. I think if you've tried to figure out the headaches now, you realize this short-term, long-term distinction just is not going to work. In terms of how to apply the opinions on their face, it's tricky because Alito's view in Jones was premised on the absence of legislative regulation. He says, we really want legislatures to solve these sorts of problems, but in the absence of legislation, this is what we're going to do. And he comes back to this in his concurring opinion in Riley, where he says that if there were legislation governing search incident to arrest, he would defer to the legislation and not use the Fourth Amendment to reach that result. I think there are problems with linking the constitutional rule to the statutory rule, but if you take that idea seriously, the answer in Carpenter should be that the Mosaic approach doesn't apply because Congress has regulated under the Stored Communications Act. I think there are problems with that, but I think there are problems with the Mosaic approach too. It's really, I think, ultimately difficult to say where the different votes are going to go. It's just too hard to predict.
Great, Alex. Your thought on how the court is going to go, and Orin just made two important points. One, that the Mosaic theory is really hard to apply. It's hard to draw the line. And Justice Alito and the late Justice Scalia had a debate in Jones about where to draw the line. And Justice Alito said if the police aren't sure, they should just get a warrant. And second, he says that Congress has legislated here, unlike in Jones, and therefore Justice Alito might change his vote. What do you think?
Yeah, well, let me start with, take those backwards. So Congress legislated in 1986. I don't think, I'm not sure there's any dispute in the briefing in the case that Congress didn't have cell site location information in mind when it enacted the statute in 1986, and that the technology was radically different back then. So I think it'd be a mistake to think that Congress has tried to address these questions. But the first question, I think, is the critical one. And I think the government's strongest argument, and I think Orin's strongest argument, is that it is going to be messy to apply a rule that is not as bright as the third-party doctrine. But that shouldn't be surprising. The reality is that analog-era Fourth Amendment law is every bit the maze that a world without the third-party doctrine would be. If you studied it, you know that there are conflicting and complicated rules. There are exceptions to those rules. There are exceptions to those exceptions. And there are even cases where the courts just engage in straightforward balancing of interests rather than appeal to some bright line rule. And the result is that you have the same sorts of questions that Orin raises with respect to the Mosaic theory you could raise about traditional analog era cases. If the government asks for your consent to search your house, the government is generally fine. What about a roommate? What if they think that person is a roommate, but the person is not in fact a roommate? What if it's shared custody? Can the government erect a drug checkpoint on the roads? Does it matter if it's roving or stationary? Does it matter if you have the opportunity to avoid the checkpoint? If they stop your car, can they search your glove compartment? What about the trunk? What if the trunk is locked? If it takes long enough, can they wait for a canine unit to come and sniff the trunk to see if there are drugs there? If it doesn't take long enough, can they force you to remain nonetheless? Can they collect the DNA of convicts? What about arrestees? What about arrestees of serious crimes? I mean, these are the questions of the Fourth Amendment, and they are all hard. Orin is proof in point. Orin has, one of the reasons his career has been so successful is because of how complicated the doctrine is, and he has spent it trying to unravel the maze. And so the reality is that we may need to replace some of the maze that we currently have with a new maze. And I think it's worth it. It's worth it because the alternative, a bright line rule that has little relationship to what people actually expect and little factual foundation in modern realities of surveillance, would leave entirely unprotected the vast majority of information that people care about today. And I don't think that's consistent with the command of the Fourth Amendment, which again isn't the third-party doctrine. The command of the Fourth Amendment is unreasonable searches or seizures. And the final point is I don't think it would be even as hard as all of that, because I think Orin is right that at the end of the day, Congress would pass a statute, and I think that's fine. It turns out that there are a number of contexts where the Supreme Court will rule in a Fourth Amendment case. Congress will realize that the resulting rules will take a long time to develop, and they want more certainty faster, and so they legislate. The classic example is Title III, the wiretapping statute. In a couple of cases, the Supreme Court in, I think, 1967, invalidated warrantless wiretapping. This is the famous Katz case. That same year, I believe, they invalidated New York State's specific wiretapping statute in a case called Berger versus New York. And within 6 months, Congress had legislated and created Title III, 7 months maybe. And that was the model. And the same happened with the Foreign Intelligence Surveillance Act. In 72, there was a seminal Supreme Court case invalidating warrantless wiretapping for the purpose of certain forms of national security surveillance. Congress kind of indirectly responded a few years later with the Foreign Intelligence Surveillance Act, which is even more complicated than Title III. And I think the same thing would likely happen here, and I think that's probably the right result. And that's not to say, to admit that Congress should have some role is not to say that the courts shouldn't have any role. The role of courts, I think, when it comes to constitutional amendments is to ensure that there is a floor. And I think courts are well within their judicial role to say the floor that Congress has currently set up, the Electronic Communications Privacy Act of 1986, the one that says you can get this order on a showing of specific and articulable facts to show that the evidence is material. And by the way, location information will be material in the vast majority of cases. I think it's fine for courts to say that floor is too low. That's below the constitutional floor. In reality, it's somewhere higher, and we're not going to tell you exactly where it is right now. We'll give you a chance to legislate, and we'll decide over time, if we're forced to, what the rules are in exactly the same way we've done with the rest of thorny Fourth Amendment doctrine.
Great. Orin, I want to understand if there are any limits on your powerful argument in your brief that we should not have constitutional protection against observation in public, even when it's technologically enhanced. Could the government fly a tiny drone in the air with a camera and fix it over someone, say me, and follow me from door to door 24/7, reconstructing all of my movements in public for a month without a warrant?
Yeah, so let me give the traditional, boring doctrinal answer to that question. I know doctrine is something we shouldn't be talking about here. We're all very grand principles about the role of the courts and all that kind of stuff. But the doctrinal answer would be the government is allowed to monitor somebody from public airspace as long as they're not breaking into someone's property by going below public airspace, and that whether it's long-term tracking or short-term tracking doesn't traditionally make a difference. And so they would be allowed to monitor from public space and follow someone. And that would not be it wouldn't at some point become a Fourth Amendment search. And I think that's as a Fourth Amendment rule, that's an understandable, coherent Fourth Amendment rule. You'd want to have statutes that limit the government's ability to do this. And I think the fact that we're having this debate and that Carpenter is a high-profile case shows, to my mind, how the legislatures are ultimately the right institutions of government to be grappling with this. Because when we talk about what privacy rules there should be, it's like, well, people demand privacy in this. It's like, well, we have a body of government under the Constitution that is designed to reflect what the people want in terms of limits on government, and that's Congress is designed to reflect public opinion on what limits they might want, and the Constitution is a floor, but it's not everything. And so I think that traditional approach, where I would say there's no kind of point where after 29 days is okay, but once you get to 30 days, a switch is turned, and that becomes all a retroactive search. I would reject that idea and say that as long as they're in public airspace, it's not a Fourth Amendment search, but something that should be regulated by statute.
Great, a very clear and understandable answer from Orin. Alex, do you think that the Constitution would allow 24/7 ubiquitous tracking of our movements in public? Justice Sotomayor, in her concurrence, said, if the answer is yes, then we have no privacy in an age when all of our data is stored on third-party servers and when the government can reconstruct our movements. And I know you think the answer is no. If you were writing the opinion, by Justice Sotomayor or Justice Alito, what would the constitutional argument against that kind of ubiquitous surveillance in public be?
Yeah, so I would approach, and this is will frustrate Orin to hear me say this, but it won't surprise him. I would answer the question narrowly. I would say absolutely, long-term ubiquitous surveillance of individuals is an unreasonable search or seizure within the meaning of the Fourth Amendment. And I might say, beyond a certain number of days, but at the end of the day, I think Orin is right that legislatures will have an easier time figuring out what a reasonable balance is. But to say that doesn't mean that constitutional rights, which are meant as bulwarks against majoritarian rule, should be ceded entirely to majoritarian rule. I don't think that's the purpose of the Bill of Rights, and I think it'd be inconsistent, because while maybe this Congress or some other Congress might one day choose to reform the Electronic Communications Privacy Act, it hasn't for 31 years. And even very, I think, modest reform measures in the past few years, ones that would, for example, make clear that your email is protected by a warrant, haven't been enacted. And so I would approach it cautiously from the Supreme Court. I wouldn't try to articulate some grand vision of what is reasonable and what is not reasonable under the Fourth Amendment, in part because I think as elegant as it might be to have that sort of solution, I don't think that reflects the reality of privacy and the reasonableness inquiry on the Fourth Amendment. I think and you have that proof in the doctrine already. And just to complicate Orin's answer a little bit, I believe, you can correct me if I'm wrong because you know this doctrine much better than I do, I believe the Supreme Court has only said that that form of aerial surveillance is constitutional if it's above 1,000 feet, which is the Cirolo case. I think that was the factual presentation there, and the Supreme Court several times, every time it articulated the rule, mentioned that the plane was flying at 1,000 feet and no lower. Whether that matters or not to the doctrine, we don't know, because I don't think the Supreme Court has had another case, unless I'm wrong, about whether 500 feet is okay or whether 10 feet is fine. So that's how I would approach it. And can I say one other thing too? So I haven't responded to something Orin said a couple times, which you asked about, Jeff, which is this question of the eyewitness rule. And one thing I'd be interested to hear your response to, Orin, is I think it's tempting to think that this eyewitness rule, the idea that if there's somebody who the government could subpoena to testify, then you can't have an expectation of privacy in that. I think that's roughly the eyewitness rule. In your brief, you say that that would preserve the traditional inside the envelope, outside the envelope distinction. And I'm not sure that's true. Email, I don't think, is generally limited in who can read it to the sender and the recipient. When you send an email over Gmail, you understand through the terms of service, you probably don't, you may not have read the terms of service, most people haven't read the terms of service. Whether that matters or not, I guess, is another question. But you are at least on constructive notice that Gmail reserves the right and does, in fact, scan your email for spam. It scans it for child pornography. It scans it for malware. When it gets to the other end, it scans it for all sorts of reasons to present it more usefully to the user. It scans it to see whether there is a travel reservation inside, and so it adds it to the person's calendar automatically. It scans it to see whether there's contact information that should be added to the contact list. It scans it to see whether it's important and in line with things that you have read a lot before, or the sort of thing that you typically delete right away, and then it shows it either in the high priority section or the low priority section. That kind of review, I think, is inconsistent with what you say in your brief, that email, under the third, the eyewitness rule would fall clearly on the inside the envelope part of the theory. But maybe I'd love to hear if Jeff allows.
I allow, but I want to frame, in addition to answering Alex's question, answer this broader question. You gave a clear answer. It's up to legislatures. What is your response to the claim that legislatures have not and are unlikely to regulate in this space? There's been a geolocational privacy bill co-sponsored by Republicans and Democrats on the books for years that hasn't passed. And what should we make about, given the fact that when I ask groups whether they think that tracking someone's movements 24/7 in public with drone cameras violates the Fourth Amendment, the answers are overwhelmingly yes. And I won't poll this group. Well, what the heck? We can have real-time polls in the middle of this discussion. Who believes that the hypothetical I posed to Orin, where the government would track our movements 24/7 in public for a month using drone cameras, would violate the Fourth Amendment?
And can I ask a follow-up question?
Wait, let's have and who believes it would not?
And
yes,
can I ask a follow-up question for
please.
those that raised your hand the first time? How many of you think that Congress should enact a rule limiting that? Oh, yeah, there we go. Yeah.
Okay.
But that's not inconsistent, is it?
Okay. So the point of this exchange is many people think Congress should, but it hasn't and may not, and yet most people think it violates the Fourth Amendment. So what's the Supreme Court supposed to do about that?
Right. So let me first talk about what it means to meaningfully legislate. So this is Carpenter just filed the reply brief, I think, yesterday, and Carpenter says, well, yeah, Congress has had lots of hearings on this question, and sure, in 1994 they enacted the specific and articulable fact standard, and yeah, a lot of state legislatures have enacted warrant requirements, but there hasn't been a meaningful legislation. Now, what is meaningful? I assume meaningful means enact the rule I want, and then there is meaningful legislation. I don't think it can be the rule that if you don't enact the rule the person wants, Congress is not meaningfully engaged. This is something where it's a 1994 statute that enacted the standard. Congress has had 5 hearings on it. Representative Goodlatte, chair of the Judiciary Committee, has promised more action on this. I mean, it's Congress, so you never know what they're actually going to do. But there's a lot of state activity going on. California enacted CAL-ECPA, the California Electronic Communications Privacy Act, the most far-reaching statutory privacy law ever enacted for electronic or digital communications. Very broad warrant requirements. And so this is a statute that goes very, very far in enacting warrant requirements for almost everything except for basic subscriber information. Maybe that's a good idea, maybe that's not a good idea, but there's a lot of legislative activity going on in this area. So I think it's wrong to say, well, I don't see, Congress has not actually enacted the law I want, therefore Congress is not meaningfully engaged. And with respect to drones, I think in the last, I looked at this a year ago, in I think 2015, I think 9 states had enacted drone legislation of some kind. So this is something that at the state level, the states are worried about and are enacting rules on, and good for them. I mean, I think that's something that different legislatures should have rules on. So I think it's really important to not sort of say, just because I don't see the rule I want, and therefore Congress isn't doing the job. They're actually, I think, doing a lot, and state legislatures too. On the question that Alex raised about content versus non-content information, so let me step back a little bit. My view that the legislature should take the role with respect to non-content information would be contrasted with the idea that I think the Fourth Amendment protects contents of communication. So the Fourth Amendment protects the contents of your emails that are remotely stored with service providers. It protects the contents of your text messages as they're traveling. And what is contents, the cases on this, there was a recent Third Circuit case suggesting, for example, that when you search the web, everything beyond the .com part, so everything beyond the domain name, is contents of your communication. You're sending a request for a specific web page, and that's a message you're sending to the server, give me a particular web page. That would count as contents. Under my view, that would all be protected under the Fourth Amendment by a warrant requirement. The difference, as I see it, is that it's basically a reconstruction of the traditional Fourth Amendment rule that you have privacy protection in your home, in your inside spaces, as applied to the network environment. So the way I think of it is that in the Fourth Amendment world without networks, you have Fourth Amendment protection inside your home, you don't have protection outside, and when you hire a network provider, whether it's a cell phone provider, an email provider, or the postal service, you're basically saying, okay, instead of me having to go out into the world, I'm going to hire somebody else to deliver this communication for me, and that equivalent network information of what would have been publicly observable stuff, like I left my house, went to a particular place to deliver my communication or to have my conversation at my friend's house. The fact that I left my house, the fact that the travel was made, that would traditionally be exposed and available and therefore not protected under the Fourth Amendment. The actual contents of my communication inside my house would be protected. So as I see it, the content, non-content distinction, which happens to have been adopted in cases like Katz and Smith versus Maryland, is accurately reconstructing that traditional inside-outside distinction from the physical world for a network environment, and therefore is this kind of technologically neutral principle which can apply in the internet. And it would mean that it's not that, go online, you have no Fourth Amendment rights. It's go online, you have Fourth Amendment rights in the contents of your communications, but the rules governing access to your non-content records would be statutory and not constitutional. That would be my approach.
Great. Alex, much of this discussion is a debate about how to translate the Constitution in light of new technologies. And one of the great opinions about constitutional translation of the Fourth Amendment came from Justice Louis Brandeis in the Olmsted case involving wiretapping in 1928. And in that decision, Brandeis seemed to look forward to this case that we're talking about today, to an age of cloud computing. And he said prophetically, ways may someday be developed by which it's possible, without physically intruding into desk drawers, to extract secret papers and introduce them in court. And then he said advances in the psychic and related sciences may make it possible for the government to reveal unexpressed thoughts, sensations, and emotions. Brandeis's concerns have come true if the court refuses to translate the Fourth Amendment to restrict this kind of surveillance in public. Tell us about what the consequences would be. What would the government be able to seize, and what would Brandeis think?
Yeah, I think he would be very vindicated. And the consequence is that the litany of things I tried to use to scare everyone earlier would be the sorts of things that the government could collect. It could collect virtually every piece of digital metadata trail that you leave. You are all now carrying very sophisticated tracking devices in your pockets or in your purses, and those reveal a lot of information about you, including health-related information, location information, who you're associating with. And it's important to understand that the analysis of that information is getting very, very powerful. The government, it's not just that the government knows that you're here, it knows that you're here, or could know that you're here with other people. It's not just that it knows you're at a particular house, it's that it knows who else is at that house, at what times of day. And it's not just that it knows you placed a call to somebody, it knows when you placed that call, how many times before you've placed that call, who that other person has called. All that information would be available to the government. And I think all of that is relevant to the question of whether the search is reasonable. It's not true that Fourth Amendment doctrine has been concerned solely with the places of surveillance. It has also been concerned with the sensitivity of the information revealed. And there are two axes, and one of those axes is often more relevant than the other, depending on the form of surveillance. But the court has been concerned about both. There's no other way to understand Riley. Riley was not a case. This is the search of a cell phone incident to arrest. Riley was not a case where the court said, where it would focus on the first of those questions. It didn't carve out cell phones as being unique physically, that they were a unique physical space. They were different from a billfold or a packet of cigarettes because of the sensitivity of the information that people store on them. I don't think there's any other way of understanding that. And I think email and even phone communications are the same way. You reveal that information. You reveal your email to Gmail every time you send that email, whether you like it or not. That's an incident to using the technology. We can come up with ways of distinguishing that through some inside the envelope, outside the envelope analogy, but the truth is the analogy isn't perfect. And the real test of an analogy is not in its similarities, but in its dissimilarities. And modern day surveillance is just fundamentally dissimilar from the form of physical surveillance that the third party doctrine was meant to regulate.
Response, Orin, and this gets to a debate between Justice Alito and Justice Scalia in the Jones oral arguments. Justice Scalia said we have to ask what the framers thought, and Alito said they didn't think about GPS surveillance. And Justice Scalia said, but there's an analog. You could have, at the time of the framing, a tiny constable spirited under a carriage and eavesdropping on the conversations. And Alito said you need 1,000 constables to get the coverage of a single GPS device. They'd have to be very small constables or a very large carriage. So Alito and Alex and Justice Brandeis are saying that when electronic surveillance can reveal even more about us than the general warrants that sparked the American Revolution, then the warrant requirement should be triggered and existing doctrine should be reconsidered. Response.
Okay, let me go back to Brandeis, because you mentioned Brandeis's dissent in Olmsted. If I recall correctly, there were two different parts of Brandeis's Olmsted dissent. One nobody talks about, and the other everybody talks about. Everybody talks about the Fourth Amendment part, where Brandeis says wherever there is an invasion of privacy, it should be prohibited by the Fourth Amendment. And at the time, there would have been no warrant that could have been obtained because the communications that were wiretapped would have been mere evidence, and therefore the government would have just been, basically, if it's on a phone call, you have sort of a fundamental right to have a phone call without the government listening in, no warrants, total protection. That was Brandeis's view. On the Fourth Amendment part, the other part of Brandeis's opinion was about the Washington state wiretapping law, a statute. And the other argument in the Olmsted case was that the Washington state wiretapping law was violated by the federal prohibition agents, and there should be a suppression remedy for violating the statute. And Brandeis argued that there should be a suppression remedy for violating the statute, and Holmes's dissent focused on that part. If I recall correctly, he didn't touch the Fourth Amendment. He only talked about the statutory issue. Now we can talk about whether the statutory analysis is right or wrong, but I think the key lesson there is that even in the Olmsted era, this was something that was proceeding both as a matter of statutory law and as a matter of constitutional law, and trying to figure out the role of those two different branches was a theme even at the time. Remind me of the second question, the new question.
Well, the new question is, everyone thinks when you are revealing even more information than the general warrants that sparked the American Revolution, you got a Fourth Amendment problem, don't you?
Yeah, so I think the general warrants were about breaking into private spaces like homes and offices, and how broadly should the judicial authorization be with respect to breaking into those private spaces. Here we're not talking about breaking into those private spaces. So there's no need for a warrant under the traditional Fourth Amendment view, so there's no question as to what is a general warrant. The Fourth Amendment did not say the government can't look all around to see where there's evidence of crime. They can't, they should only walk down a street, they can't walk down 2 streets, all that kind of stuff. That's not something the Fourth Amendment has traditionally regulated. I think the big moment of misunderstanding is in the Katz case, and in particular Justice Harlan's concurring opinion, which unfortunately Justice Harlan didn't add the citations he needed to. He says in the opinion, here's my understanding of the rule that has emerged from past decisions. Searches require 2 things. And what are those 2 things? Well, it needs to be a space that is protectable under the Fourth Amendment. And there had been a lot of cases as to what spaces were protectable. Homes were protectable, open fields were not protectable. And the Katz case had said that a phone booth was a protectable space. And so that's, Harlan describes it as being, well, there's a reasonable expectation of privacy. Sort of, I think of that as being, it's sort of home-like, or something that is that person's stuff, at least when they go into the phone booth and close the door and put in the coin, as Harlan puts it. And the other is that you need to manifest a subjective expectation of privacy. You need to exhibit a subjective expectation of privacy. And it's unfortunate that Harlan didn't include citations to that. If you were in 1967, you would know what that meant if you were familiar with the Fourth Amendment cases at the time, because in the preceding 5 years, the court had decided something like 7 or 8 cases involving undercover agents, or contexts where a person said something where others could hear it, and then the court said, well, if you said it where other people could hear it, you have no Fourth Amendment rights. I think exhibiting a subjective expectation of privacy, that language was not about kind of actually expecting privacy. It was about, did you disclose the information in a context where others could hear it from a protected space? And if that's right, this whole idea of reasonable expectations of privacy, that was really just Harlan's way of describing what are the physical spaces that are home-like enough or sufficiently private as spaces where we should say somebody has Fourth Amendment rights in that space. So phone booths count, homes count, trunks of cars, cabs count. Those are what the prior cases had said, but open fields don't. And this is an open fields case. So I think under the Harlan approach, the answer should be this is not something the Fourth Amendment does. What's unfortunate is that the way Harlan phrased it, expectation of privacy, society is prepared to recognize as reasonable, that can be read out of context, and I think unfortunately has been read by some courts as sort of a free form, like, I don't know, you seem like a reasonable person. Do you expect privacy in that? And then it sort of becomes this really vague, sort of meaningless, how do you feel question. And I don't think that's what Harlan had in mind. I don't think that's what the Fourth Amendment is dealing with. And so I think that the reason we're asking these questions, some of these questions, if you look at the Harlan concurrence out of context, you see, oh, that seems to be the question. I think if you understand it in historical context, the Fourth Amendment is not supposed to be this sort of free form, what do you feel, what are your expectations, you seem reasonable kind of inquiry. And that is what has caused a lot of uncertainty from the Katz case going forward.
Great. So Alex, Orin has said something important, which is that this test that he just mentioned, which has been the cornerstone of Fourth Amendment law since the 1960s, suggests that Carpenter should lose. Because if the question is a public space one where people subjectively should expect privacy, Orin says no. And your side says, well, that means that the test itself is circular, because in a world where the government can just say, we're going to surveil you in public, people's expectations go down and surveillance in public is unlimited. So does the court have to reconsider the subjective expectation of privacy test in order for you to win?
I don't think that it does. The Supreme Court has recognized the circularity of that test before, and there was an important footnote, I believe, in Harlan's opinion, recognizing that there was a kind of normative safeguard against that sort of circularity, that if the government tried to shift societal expectations of privacy by one day flipping on the surveillance state, that wasn't going to change the analysis. But more broadly, I think I disagree with the idea that the Fourth Amendment was meant to be something where there was, a small handful of bright line rules that define privacy. If that were the case, I don't think they would have used the word unreasonable. I think that does invite the very sort of what may seem frustratingly free-form inquiry into what is reasonable. But I think that's what the Fourth Amendment was meant to do, to respond to the threats to privacy that are endemic to our time, not to set in stone expectations of privacy based on technology that were developed a long time ago. And to give one kind of concrete example of how it can be very hard to draw these lines. So Orin earlier mentioned the distinction between the domain of the website you visit and the specific page. So the New York Times' page generally versus the story on the Steele dossier. And even then, it's hard to draw a distinction between the two, because if you think that the government is allowed to sit in the position of a network observer, which is the phrase Orin, I think, used in your brief, right? If you think the government is entitled to sit in that position, one thing it will learn about the page that you visit on the New York Times site is its exact size, right? It can watch the packets come to your computer and tell you the size. And it turns out that most subpages of a web page are relatively unique in their size. And the government can make very powerful inferences about what exactly you're reading on the New York Times site. And that's on the basis of metadata. And so that's the fundamental breakdown. Metadata now, due to the nature of technology and the nature of the government's analytic capabilities, reveals the sort of information that Orin calls content and that I think the founders would have said are the things that they want protected. And I think that's the reality we need to deal with, and why a kind of rigid application of the third-party doctrine without re-examining what we're trying to protect doesn't make sense.
Orin, on the third-party doctrine, the guy who argued the case, Smith versus Maryland, has said that he thinks it should not apply in this case. I know this because I was giving a privacy talk in upstate New York and talking about Smith v. Maryland, and someone in the front row stood up and said, "I argued Smith v. Maryland. I think it shouldn't apply to this Carpenter case." Yeah,
He's a partner of Wilmer.
Yeah, former Attorney General. Yeah, and his reasoning was, I was talking about bank records or phone records that you knowingly turn over. The quantum of this information is so great that we're really somewhere else. And Justice Sotomayor said the same thing. I understand your practical concerns about coming up with an alternative, but what do you say to people like the guy who argued Smith v. Maryland, who said that it shouldn't apply when you're revealing so much information about our movements?
Yeah, so I think it's hard to come up with a constitutional rule that says you can disclose some things, but other things in some undefined way, once you disclose those, then that starts to become a search. It's just really hard. These are line drawing exercises which involve, think about this, is a constitutional non-disclosure rule as to when a private party can say something to the government without a warrant. And so what are those things that the private party can't say, and how much of those things? And can they say just a few things? Once they start talking after a while, maybe a warrant is required. It's hard for me to come up with a constitutional rule that regulates that. We can do it easily through statutes, right? And that's what the Stored Communications Act does, and there are ways we can improve the Stored Communications Act, I think, to make it more nuanced and improve some of the privacy protections. But I don't see it as something that you can have a constitutional rule on. And I think it's telling that Carpenter's side won't come forward and say, what is that proposed rule? They'll just say, this is on one side of the rule, and we don't know what the rule is, but we'll have more cases, and then maybe that we'll figure out what the rules should be. And that includes academics. And so when Jones came out and the concurring opinions came out in 2012, I wrote an article called The Mosaic Theory of the Fourth Amendment, pointing out all the problems, of the line drawing problems of how are you going to implement this. And whenever I'm at a Fourth Amendment conference, I'm really good fun. I'll poke people whenever the Mosaic Theory is mentioned. Yeah, how would you implement it? And no one wants.
Twitter. You did
I'll do it on Twitter too. No one wants to answer these questions. 5 years later, what the most I will get is some people will say, if you gave me funding, I would think of what the answer should be. But you can't just put me on the spot. That's unfair. And others will say, I don't know. This is academics. I don't know the answer. I'm a law professor who teaches Fourth Amendment law and have for 30 years. I don't know the answer. But judges are very smart people, and they'll figure out the answer. And I'm not saying that the answers have to be right, but there have to be some sort of answers. And the fact that academics are not eager to offer their own views as to how to implement this theory, to my mind, is telling. And I also wanted to go back to something that Alex mentioned, I think that is a good and important point. I mean, the difficulty of distinguishing content and non-content, those lines can be pretty difficult to draw. In my view, that's exactly the same problem you have in the physical world, distinguishing between outside and inside. So breaking into a private space is a search under the Fourth Amendment. Observing from outside is not a search. And there are a lot of cases on exactly where the line is between what counts as breaking in and not breaking in. Think of Kylo, the thermal imaging case. 5 justices say observing the temperature is like going in. 4 justices say, no, that's like being outside. Open fields cases like Dunn, where they have this test to figure out how close do you need to be to the house for it to be inside the curtilage versus open fields. So there's always going to be a close call line drawing in some cases. But I think that's a pretty narrow area of uncertainty. It leaves most cases clear. And I'm worried about a Fourth Amendment test, which really just opens everything up to something that even the academics can't or aren't terribly willing to answer.
Great. We have about 4 more minutes and then closing arguments. Alex, Justice Sotomayor in the concurring opinion said, inside-outside makes no sense in a world where we store our private papers not inside in locked desk drawers, but in this new space called the digital cloud, which is neither inside nor out. But yet Orin, and she said we need an alternative test. And Orin said, no one's come up with an alternative test. So what is your alternative test? You're standing before Justice Sotomayor, and Justice Gorsuch maybe is, skeptical because he wants a clear test. Answer Orin's question and give the court a test.
So I would do exactly what the lawyers in Katz and the lawyers in United States versus U.S. District Court, the Keith case, did then. They would articulate a constitutional minimum that was sufficient to address the case before the court and leave the rest to further development. And one advantage to that, so if we were here talking not about this case, but about drug checkpoints and the constitutionality of drug checkpoints, we wouldn't need to answer the half a dozen questions that the Supreme Court has now had to deal with when they first said some form of drug checkpoint is constitutional. And I think the same is true for metadata. There are different types of metadata that should be protected to different extents, and what the court should be doing is setting constitutional minimums in various circumstances. So for this case, if I were up in front of the court and asked the question, I would say it is sufficient to address this case that the long-term collection violates a reasonable expectation of privacy of these records, and leave it at that, and require the government, at least in these circumstances, to get a warrant. And Congress can further flesh out the rules, and if those rules are largely reasonable, I anticipate courts would affirm them, they uphold them, and that would provide the kind of predictability. In the same way that the Foreign Intelligence Surveillance Act did. Nobody, when the Keith case was being litigated, had drafted what is now the Byzantine set of rules that govern foreign intelligence surveillance. Nobody had in mind, for example, if anyone is familiar with that statute, you can go and look at the definition of what electronic surveillance is. And that alone, just what the statute covers, is a maze. And nobody was having that debate at the time of Keith. And I think appropriately so. Because I agree with one thing Orin said, which is, I don't think it's the role of courts in the first instance, where they first come upon a thorny thicket, to try to articulate every rule that would apply to every circumstance. That, I think, is a kind of, that reflects a kind of judicial maximalism that would be unproductive in this context. I mean, can I also just respond to one or two of the things Orin said? So I think it's, I don't think the rule that the Carpenter lawyers want is a rule against voluntary disclosure, a constitutional rule against voluntary disclosure. I think what they want is a rule against, a constitutional rule against warrantless, involuntary, compelled disclosure. They don't want the government, absent a warrant, to be able to force Verizon to turn over the locations of its of people, its users. But if somebody at Verizon had noticed suspicious activity on an account and gone to look at it and had it in their mind, and then volunteered that information to the government, absent the statute, that wouldn't trigger any legal prohibition. It certainly wouldn't trigger a Fourth Amendment prohibition. And so I don't think it's quite as, I don't think the question is quite what, the way you were articulating it, Orin. And I had a second point, but I forget what it was. So.
Great. Orin, one more beat to you, and then we're going to have closing arguments. First, Alex says, Google and Microsoft and Apple have joined this case because they don't want to be forced involuntarily to surrender all of the private data in the world that they hold because they think that that would violate privacy. So how much of this case turns for you on the fact that it's geolocational information which is automatically turned over rather than seized? And then you say it should be done by statute. What's the statute, state or federal, that you think best draws the line, and how does that statute draw the line?
Great. So to my mind, it's incredibly important. It's basically the case that these are third-party generated business records. These are records that the phone companies have on their own, that they're using for business purposes, and then the government is coming along and saying, give us those records. Very, very different case if we're dealing with a government order to search the phone, to grab information from inside the phone, something that the phone company is not otherwise generating. That is an entry into the phone, not collecting a third-party business record. So at least ordinarily, I would think that would be a search. And so I think that is a hugely important distinction. In terms of what statute would be best, I think it's tricky. It would depend a lot about how the technology is changing over time. I think the 2703D current standard, the specific and articulable fact standard, makes sense for access to historical cell site records so long as they're pretty general, what neighborhood somebody's in. The difference between the current statutory standard and probable cause is a difference between the standard that the government would need to temporarily detain somebody versus arrest somebody. So it's reasonable suspicion versus probable cause. It's a difference. It's not the world's most important difference. Once the government has some evidence that the records are going to be helpful, it's just a question of how strong is that evidence. What I would do, in the world where I could control what Congress did, I think the thing that Congress needs to do and hasn't is talk about the particularity of getting the records. So once the government gets the records, how many records can they get becomes a hugely important question. The Stored Communications Act couldn't talk about that, I think, because in the 80s and 90s when it was being drafted, there weren't that many records, so they weren't too worried about how many records can be obtained. If this field were constitutionalized, if Carpenter is right, either under the current statutory standard or a warrant standard, there would presumably be some Fourth Amendment particularity requirement of how many days worth of records can there be. I don't know exactly what that would be, but I think as a statutory matter, I think Congress should enact something along those lines. Exactly how to do it is complicated. I actually wrote about this in an article, but it's particularity would be important, and also watching the technology to see how precise the records are, I think would be important.
Great. Well, this has been a superb debate, and it's time for closing arguments. You're standing before the Supreme Court and have 3 minutes to persuade the justices of your position. Alex, tell the court and the audience why you believe that the warrantless search of Mr. Carpenter's cell phone records for 127 days violates the Fourth Amendment.
I think I'll be shorter than 3 minutes. The Carpenter case presents, as clearly as any case has in the Supreme Court, whether the Constitution plays a role in privacy in the digital age, or whether instead our right to privacy in the digital age is solely a matter of executive and congressional grace. And I don't think that it is. I think that the Constitution has a role to play. I think courts have an obligation to set a constitutional minimum below which legislatures cannot go in empowering law enforcement agents to spy on everybody in the country. And while we have some statutory protection now, a rule that says it's not constitutionally compelled would make me very fearful that in the wrong political circumstances, after the wrong set of public crises, those rules would be eroded. And the government would have not just the statutory authority it has now, but whatever it is able to convince that future Congress of. And I think the Constitution was meant to prevent that end. And I think to ensure that it has a role in doing so, you have to at the very least answer the threshold question of whether it applies at all. Yes. And the consequences of a no, I think, are too dramatic to allow.
Thank you so much for that. Orin, last word to you. Why do you believe that the warrantless search of Mr. Carpenter's cell phone records does not violate the Fourth Amendment?
Well, there was no search of his records. That's the simple version. Third-party business records that are created in the ordinary course of business by a company when you've hired them to deliver your communications, they may keep those records for their business reasons, and the government may access them. But the rules governing access to those records should be statutory, not constitutional. It's not something the courts have ever tried to regulate, and if they do try to regulate it, nobody, not even Carpenter, can figure out what those rules should be. So the court should allow legislatures to continue to debate these issues. Maybe we should have the current statute, maybe there should be a different standard, maybe there should be different remedies, but that's not up to the judges and the courts. That's something that should really be up to Congress and state legislatures.
Superb. Ladies and gentlemen, you've heard this magnificent debate. You've heard the best arguments for and against finding a constitutional violation here. I want you now to vote again. Who, after hearing these arguments with a completely open mind and listening hard to try to educate yourself about the correct answer, believes that the warrantless collection of Mr. Carpenter's cell phone records violates the Fourth Amendment? And who believes that it does not? And who changed his or her mind? Ladies and gentlemen, this has been a superb debate. The next Constitution Center debate is in Chicago on the First Amendment with the Federalist Society and the American Constitution Society. Let me just say this. It is so important today to bring together the finest minds in the country for civil, engaged disagreement about hard questions. I want to thank you for having turned out to educate yourself. I want to thank FedSoc and ACS for collaborating with the Constitution Center. And most of all, please join me in thanking our debaters.
Thank you, Jeff. Thank you, Kerr.